A hearty welcome to Honorable Justice K.Sreedhar and all those who are present in this hall. The object of GIPA, founded by Dr. D.V. Gundappa and Indian Liberal Group founded by Sri Minu Masani, is to promote enlightened citizenship. Justice Sreedhar Rao, born on 21/10/1953 at Bellary, had his early education at Bellary and then completed his degree and law degree at Dharwad from Karnataka University. He then enrolled himself as an advocate on 24/2/1976 and did his apprenticeship in the chambers of Sri D. Gopinath Rao and Sri A.S. Malebennur, who were then the leading lawyers of Bellary. He then set up his own independent practice at Bellary. While practicing at Bellary, he was selected and appointed as District and Sessions Judge on 15/4/1988, in which capacity he worked at Bengaluru, Karwar and Dharwad district. In all the places he worked, he displayed intellectual capacities of a high order and was known for dedicated work. With this background, he was elevated as a judge to the Karnataka High Court on 21/2000, in which capacity he has been working in all branches of law, rendering many monumental judgments with great speed and dispatch. He has authored a handbook titled The Guidelines for Settlement of Motor Vehicle Claims in Lok Adalat, which is widely read and followed by the bench and the bar. He has also written several articles on legal subjects. He has received accolades and honor from several institutions in India, one of them being Suprabhav Dev Gold Medal by the Kolkata University for his essay on criminal justice system required reforms. With all his accomplishments, he is one of the persons best qualified to speak on reforms for speedy disposal of cases. We are all looking forward to his learned lecture on the subject. After his lecture, there will be question and answer session for 15 minutes. I request the members present to frame their questions as briefly as they can. With these few words, I now request Mr. Justice Sreedhar Rao to deliver his lecture. Thank you.
Honorable Justice Putswamiji, the enlightened public of Bangalore, we have all gathered here. It is indeed a great privilege for me to stand on this platform to express my humble views on the subject. Loss delays, it is proverbial. Even in the Anglo-Saxon system, you find that the delays in disposal is not something uncommon. Even in the Indian context, we have very vituperative, scandalizing statements made against the system and the persons who manage the system. Even in the times of Aristotle, it was said, in lighter vein rather, a person who loses the suit is also defeated, who wins the suit is also defeated. In Kannada we have Geddavanu Sota, Sotavanu Satta. With all these things, it has become an inevitable institution to operate the democracy. The independent judiciary is the hallmark of democracy. It is not the elections. It is the judiciary, the right to get justice, the rule of law. So such an onerous task is on the Indian judicial system. Framers of our constitution perceived the significance of the institution of democracy. Therefore, they gave a highest pedestal no interference. Especially the constitutional courts are so empowered that they have given enormous powers, especially the Supreme Court under 142. This says, notwithstanding any legislation to do the justice, the Supreme Court can pass any orders. There is some legislative impediments or legal rights, whatever stated, that will not come in the way. So much of trust is placed. The question we should ask ourselves, that are we acquitted ourselves in the eye of public? My role is very critical. Honorable Justice Puttu Swamiji, he has hanged his boots, and then he is at leisure. But I am still in the system. Still in the system. I should be very cautious. It is something like asking an accused to confess his guilt. Self-recrimination. This is the very delicate situation I am faced with. We have basically the two facets in our adjudicatory system. That is, one is civil litigation, we call it, other is criminal litigations. If you look at the civil litigations, first let us deal with the civil litigations. We have by and large borrowed the concepts of common law. The Indian Contract Act, basic legislations, the Contract Act. It imbibes all the principles of common law, and they are very salutary, very rational. Contract Act only says do's and don'ts. Absolute freedom, you can enter into contract. Do's and don'ts are prescribed. Within those parameters, you can enter into contract and do it. Then you have this Transfer of Property Act. And you have this Specific Relief Act. That's, see, it was in the common law. The common law courts were very, very rigid. And almost like Shylock, the interpretation, not flesh, a pound of flesh without drop of blood. That was the type of interpretations the courts were indulging in. The king found that it is very irrational. Then he created chancery courts. With equity jurisdictions, they started functioning. So what is equitable? More than the law, what is equitable? Equitable considerations also seeped into the decision making. All that equity jurisdiction is our Specific Relief Act. And you have this regulatory like this Registration Act and all that, because to give some sanctity and other things for documentation, you have the registration. If any value more than some value, it should be registered and all, it should be in written document, all that. We have these substantive laws, and then we had procedural laws. The Code of Civil Procedure and Code of Criminal Procedure are the procedural laws. If you look at our legislative format, there is absolutely no fallacy in the substantive laws. They are wonderful and excellent. They declare the rights. And they clearly define the rights of the people, rights of the parties, and then also deal with the remedial measures that is to be obtained from the courts. In Contract Act, you have got this, what you call this, damages. injunctions and you get the damages, if supposing. And in specific relief act, you have got this different relief, specific performance relief, declaration reliefs. So remedial measures are also incorporated in these substantive laws. The problem always arises with the procedural laws. It is basically because the British had a distrust. They always felt that Indians are lesser in morals and ethics. That is the psyche they carried. I still remember an anecdote in Bellary District Court. It was in those days. It was said that some English judge, there was a practice, white gloves practice. Supposing for a particular calendar month, there is absolutely no sessions case pending. Then the public prosecutor, the white gloves presentation was being done. That, of course, that convention is discontinued now. In one of such functions, it seems that one English judge made a statement that your Evidence Act is also based on the premise. The Indian Evidence Act is also virtually based on the premise that Indians are liars. Then the public prosecutor, then he was an Indian, he threw the book and with a note of disapproval saying that it is disparaging and you can't culminize the entire class and society as liars. The Indian Evidence Act also, the corroboration, the concept, when we say something, when I say this has happened, then immediately the courts, the tendency of the courts is, yes, what is there to corroborate that fact? This rule of corroboration is introduced by the judges, not by the law. Evidence Act never says that. Because this rule of corroboration is invented only to see that they never believed. You want one witness. If you say something, you should have with a witness, you must say that. This is the psyche with which they did it. And even in procedural laws also, this prejudice, irrational prejudice has seeped in. The Civil Procedure Code is heavily loaded in favor of defendant and suspects the plaintiff. That psyche is also with the courts. Whenever you file a suit and take an injunction, you suspect. And sometimes I find that suspicion is also valid because in our legal system, the persons who come to the court, often we find those who misuse the law, misuse the system, they come to the court. The bona fide users of the system, they are few in number. The people who come to the court, larger in number, are the persons who misuse. This, as I said, this Code of Civil Procedure, it is almost a second trial. Impossible to make the decree, or it is virtually it is impossible to operate, and the decree obtained becomes virtually infructuous. The party has to undergo so much of tests and other things. The leverage or the opportunities given to defendant to escape is so much that quite naturally an unfair advantages are ingrained in the law. Unless you eliminate this unfair advantage, nobody is prepared to come honestly and do that. And another interesting thing in the CPC, always found that normally our understanding is when you say yes, you admit it. Means what I said, when I say something, you say you have admitted it. But in CPC, that's not the concept. What is not denied is admitted. When plaintiffs make some statements, defendant writes something. If he doesn't deny, it says it's admitted. What is stated, it is too technical. That is the reason the written statements are so prolix. The lawyers do not take a chance. They try to deny even any smallest statement. Instead, he gives a version and let the defendant say, this is my version. Implied denials are there, but law insists specific denials. And then we have in the CPC, adversary, blindly we follow adversary system of trial. That means to say, plaintiff says something, defendants deny it, issues are framed, and it is for him to prove, burden of proof and then onus of proof, all these things are there. Is it necessary that adversary system should be allowed, part to be adopted in all types of adjudications? As a district judge at Dharwad, I found in one case, it was a case, some nuisance. The first floor man, he was not properly managed his bathroom. It was leaking. The ground floor, he always found it very difficult. He filed a suit. It took almost 8 years. It came in appeal. We confirm it. It came in appeal. What is the relief he gets it? Is it necessary? See, because it's adversary system. In adversary system, the parties are asked to demonstrate or produce evidence by way of oral evidence before. Even when object is visible, the judge doesn't go and see at it. They want, no, you want something like explain the blind man explaining the elephant. Our CPC has underwent amendments in 76, 2003, 2002, but still we have not applied our mind. The case is inquisitorial, where you can go to spot, the boundary dispute is there. Why there, within 1 hour you can solve it. The judge, anybody can go and then they can call the revenue records and then survey it and they can close the matter. Why do you adopt an adversary system? It is something like a square peg in a round hole. These procedures, blind following of advice, and sometimes I think there's a certain exceptional relaxation in some legislations where the compensatory legislations like motor vehicles, judge can involve himself. But here, in civil litigation, he should be like an umpire. He should distance himself from the facts and the parties, and whatever stated, alone he should decide. This is the procedural methods, mechanism of adjudication. This adversary system of trial should be relaxed. It is necessary to the cases where it is rational, you can adopt. In cases where investigative type or inquisitorial type, you can adopt. We have not provided that procedures in the CPC. Then you have this concept of multifariousness. In law we call multifariousness. That means to say that the court can decide the litigation between two individuals. The third claim, if it claims, the court cannot do it. Many a time this multifariousness has created multiplicity of proceedings. Supposing if 3 persons are claiming title over the property, if it is not otherwise difficult for the judge or feasible for the judge to decide, why don't you allow in one comprehensive manner, one comprehensive litigation, allow it to be done? That technical difficulty is not permitted to ask him to file another suit and all that. That means to say the third claim cannot be entertained at all. And then you have this, what you call that, different jurisdictions. Unnecessary. The small cause jurisdiction you say, probate jurisdiction, insolvency jurisdiction, and then matrimonial jurisdiction, and then criminal jurisdiction. Even sometimes the criminal courts under 125 will grant maintenance. The same judge sitting on the civil side can attach the immovable properties. But the same judge, when he functions on 125, his hands are tied, he can't proceed against the immovable. What rationality is? Why should we unnecessarily compartmentalize? Why don't you for a common man looking at, the same judge can do it when he takes up a civil case, and if it is the name of the case or the nomenclature of the case is different, he is disabled. Why should we not rationalize? This small cause was intended because it was a summary jurisdiction, they say. If the amount is very small, doesn't require elaborate trial and evidence and other things, they thought that yes, immediately expeditious relief can be given. Because the name itself suggests small cause. It's a small cause, it can be immediately done. But in reality, the situation is different. Small cause cases are as bad, dependency is as bad as regular suits. And I'll tell you one practical difficulty. You say that some of the claims which are included in small cause cannot be entertained by regular civil court, especially these tenancy disputes. You say that if the question of termination of tenancy, legality of notice and ejectment, then they say you should go only to small cause. It was done perhaps with an intention that the person gets immediate remedy. But the result is otherwise. This confusion always prevails. And question of denial of notice and other things, that is not determined until defendant appears. Only by his written statement you can know. And if it doesn't take that defense, it's well and good, some small cause get jurisdiction. If it takes the defense, again the matter becomes cumbersome. And it's confusing. And the cases come up to second appeals level and Supreme Court level, that this subject should have been decided by a small cause court and not by a civil court. For what good? These are the practical potholes, or say drawbacks in the system. These, as I said, unfair advantages handed out in the legislations. You find that the Rent Control Act, the most culminized and then criminalized enactment was the Rent Control Act, 1961. It was done with legislation was done with some honest intention. But when it has outlived the utility, or the circumstances have changed, the legislature should prune the legislation in tune with the demands, changing times. But that is not done. Normally our attitude of the legislature is pass an enactment, leave it to the hands of judiciary, and don't even bother about what happens. I'll tell you the section 14 of the Hindu Marriage Act, 56, Hindu Succession Act. 56 was the legislation. See, in the 1933 Act, women had limited right, reversionary rights they called it. Because earlier, under the uncodified Hindu law, women had no right except Stridhan. Except for Bombay area, Mayuka, a wife was entitled to a share that of a son, and in old Mysore, half the share that of a son. That was the radical revolutionary legislations. Otherwise, in Madras parts and other things, women never had a share at all. It is only for the first time under section 6 that right was given in the share of the, not in the co-parcellary property, but in the share of the husband. Then the 14 deals with any property given in lieu of a maintenance to a woman. They say as on the date of enactment, subsequently also it ripens into a full right. The debate went on, the judicial debate went on, the cases went on, even till 1990s, end of 1990s, nobody knew what is the correct position. See, legislatures, they virtually became diverse from these real situations. Why don't they amend? The moment, after all, you are the lawgiver, Parliament is the lawgiver. Let Parliament and the legislatures have some audit wing of the legislations which they have made. Let them see, let them go into legislation which is being misused. Let them see legislations which are not, in what way the shortcomings of the legislations. Why don't they update it by legislative process, amendments, explanations? This attitude is totally lacking. Our legislative bodies, they become totally indifferent to legislations the moment it is framed, and it is left to the hands of the judiciary to lay down law and then interpret. So much of confusion. And precedent law also, you see, it's a weakest law. Precedent law is a weakest law. Judicial review is there. The view held by the court for the present may not be valid after a few years. That's what happened with Rent Control Act. See, even our legislations, you see, in motor vehicle case, Motor Vehicle Act, or also in the Indian Penal Code, wherever they say fine of rupees 1,000 and all that. This 1,000 of 1860, we should not forget that. And your 1930s Motor Vehicles Act, you say violation of these petty violations, jumping or that without license, without policy. And you say 500 or 1,000 of those days, if you now, it runs into lakhs. Have you updated? Money value has changed. Have you pruned the legislation? Have you updated? No, absolutely no concern at all. This indifferent attitude, that gives the total, one of the reasons. And then you have this, the court fee. Those who practice on the court fee, many lawyers pride that one who is expert in court fee is the really good civil lawyer. Because it is 1 inch above the substantive law. The provisions are so. It is one of which so wonderful decisions have come. It's only for philosophic discussion and debate, without practical utility for a common litigant. This Court Fees Act itself generates about 10 to 15% litigation. You are collecting some fees, a fiscal law, you want some money, you say yes, fix the tariff and then do it. And then these lawyers also, they indulge in playing with this Court Fees Act because they have got an injunction relief where you say it's only a intangible right and your notional value of 1,000 and then pay 25 rupees court fee. Even a big property also, where he is attacking your title, he is invading your possession and other things. Why don't you file a suit for the declaration of title or anything? It is something like you are getting where an antibiotic is needed, you take analgesic. Wrong prescriptions by the lawyers, they are tempted many a time because this is the situation. So why don't you rationalize and say, yes, this is the fee. Don't give scope for any debate or interpretation. If you are interested, I think this Court Fee Act is a total failure. Over the period, after this Teligi affair, we found that all court fee is pocketed by Teligi and we have granted judgments. All the stamps, court fee stamps, everything, it's all Teligi made. And we have faithfully rendered judgment for this consideration and all that court fee. He has benefited. And what is? See, you having seen such things, and look at the difficulty for the people. You want a bond paper or an affidavit 5 rupee paper, you have to stand in queue and back for the years. What is this nonsense? Why do you are not alive to the problems of the people? If you can't even hand out a small stamp, a common man, easily he can't walk in and then have it. The system, I say, it's a failure. And in this court, this generates all the problems. And then lenient provisions favoring the defendants. In the civil litigations, right from the written statement stage, I think most of the lawyers, I was amused when they proposed the amendment in 2003, when they said that 90 days time limit is for written statement. A well-informed lawyer should feel happy that it is a departure from the previous law, where not even a day's time is given for written statement. Under the unamended law, the settlement suit summons were sent for settlement of issues. In the settlement of issues, it was being written, that you must come with the defense and then we shall settle the issues. Instead, a departure, 90 days time is given, lawyers went on strike. Earlier law, there was no time at all, but courts were very liberal. Courts were indulging and liberal. Therefore, it is more an injunction against the court than an injunction to the lawyer. That 90 days prescription is more directed to the court, to see that court should not be more indulgent in granting adjournment. The lawyer totally misunderstood. For that, courts came to be closed for several months and years. A lot of writer's situation was created. Very unfortunate. And then the mindset, Indian mindset, I tell you, it's very interesting. Whenever anybody will advise, so if sir one notice bandinadre illa ant bardu bittu togobad nenu, don't receive the notice is the first lesson any litigant or anybody is taught in India. Yavadana mandre togondu you meet the case, take the bull by its horn anta yavadu helalla, adu bandre you avoid it. Illa anta heli kalisibid notice, adu eno the wrong concept. The constructive notice concept, people normally do not have that. People say, yes, you avoid the notice. And even if you deliberately avoids, and he also will bribe the process server. He will avoid at all times. And what is it? Even at appeal levels also the same problem. He appeared here, he would appear in the trial court. In appeal again the same situation comes. Why should? Having been once served, the same uncertain situation, why should it be allowed? Why don't you prune the law? Why don't you give teeth to the law? Of course, now that is some amendments are made, I am not very happy. And even defendants also, he has virtually a right of silence, like an accused there. He need not, supposing if somebody third party interests are there, he will not disclose. He will litigate and spend the time. After he suffers a decree, he will instigate the other man to file a suit. Saying that, no, I am not a party, I am not aware, decree does not bind me. Frivolous defenses, technical defenses. There is no substantial miscarriage of justice. And then the civil laws are also not adequate enough to punish. You make it an offense. In the CPC, you make it an offense that such and such a party and give him a punishment. Even in motor vehicle cases also we find the delay. See, after all, it's so unfortunate. This consortium of investors, I think in 2002 or 2003, they came to India to assess the situation for investments. They very correctly measured that an Indian litigation has span of 10 years. Even a compensation, a fellow who has lost a land, he requires minimum 10 years to get the correct compensation. What is the money value? 10 years ago, if you had paid the money, what is the, have you really, you are only rupee wise you are paying him, not money value. Supposing in 1970 here in Basavanagudi it was only 2,000, 3,000. But money value, it has changed. We state paying the money value to the litigant, no it is not. And again it is very stupid. See, so very irrational. Your land, see, when the Land Acquisition Act came into force, the situation was very different. It was a feudal setup. It was a feudal society. Very nascent development of this industrialization was coming in. And the lands were being acquired and divided. But now having found that, let us imagine a situation where industrial activity is to come up. A fellow has got only 1 acre. His land is acquired. The all adjoined owners, they remain, their land is intact after development, after the industry comes, they value of their lands get hiked. And this fellow is sent out. Instead, when you want 100 acres, if you are totally displacing some of the people, you acquire extra land from the person whose land is not affected and accommodate him there. He has no heartburn. This basic thinking the legislature doesn't have. Why do you send him out? Let him participate in the development, let him have the benefits of development. After all, he has sacrificed his land. What is our justice content? What is our concept? What is our vision? These are the naked things we are not able to see.
Even compound interest is not due.
Horrible. And you are say 6% interest. CPC says, what? See, banks themselves are giving 16-18% interest. And in some legislations, if it's a negotiable instrument act, they made it 18%. But if it is a CPC, they made it only 6%. What is this? Are you really compensating? And in some cases, it happens that some gold and all, the property, they say the value of that day was alone compensated, not the value of the date on the decree. Date on which he is paid, relief is granted or encashed, that is not the consideration there. And this defendant is totally a pampered child. He is not put on terms. He can remain absent, he can do all that, come with an application. So, create a level playing field. Don't hand out any undue advantage, unfair advantage. Then most of these litigations, their lifespan gets shortened. As I said, your tenancy acts, Rent Control Act, 1947 was the base for the fair rent fixation. Most of the people in this area also were occupying, having tenancies with 20 rupees, 30 rupees, where the market rent was 1,000, 2,000. Why do you have a class prejudice? Say that all landlords are rich and then affluent and all tenants are poor. This class prejudice you have in the legislation itself. And fair rent, and now that the law is changed, it was pro-tenant, now it is pro-landlord. The extremes. Why don't you make it a moderate? The legislation itself, and none of the legislations are really debated. No debate at all, and no autopsy of the provisions of the draft, nobody bothers. It just comes into being. The biggest myth in any legal system for that matter, that any law gazetted is deemed to be noticed to everyone. That gazette is invisible document. Even as a judge, I never see the gazette at all. It never come to us. But still, law declares, yes, once it is gazetted, everyone is deemed to have notice. It's a myth on which we work. And I said the misuse of law. Most of these people, they somehow manage, the police, they say you get some injunction order, we will protect you. They want some cover up. And most of the people, really weakest man, is very difficult. Therefore, many a time people come to the court and they boldly say, court go nin. Law will take its own course. Even politicians also saying that, yes, law will take. That means to say, it is an innuendo. That it's almost a mockery of the system. When somebody says, yes, you go to the court, law will take its course, andre, it never takes the course at all. It's a mockery. What happens? And then you have number of appeals and then revisions. Yeah, any one litigation, it comes up, it has got about 4 to 5 stages. 4 to 5 stages of litigation, one litigation. This is very, very irrational. And then coming to this inadequate judge strength, I just give you the interesting statistics of the pendency of cases. This, I really tell you that judges do work, but the inflow is so much that the judge strength is totally inadequate. You will be surprised to know the statistics. See, in the year 2001, the institution was 2,45,370. Disposal is 2,79,101 on civil side. That is managed. On criminal side, institution is 4,95,000 and odd. Disposal is 5,22,000. There was a sudden spurt. See, if you average of from 2001 to 2008, if you look at, the average was some 4,600 to 5,000 range. 5 lakhs, 4 lakhs to 5 lakhs range. That was the institutions. And disposals also. There is a sudden spurt in 2009 where 7 lakh cases are filed. And 6 lakhs 32,000 cases are disposed of. The backlog, the arrears, they remain as a solid rock. It is not as if that judges do not work at all. They are working with inadequate infrastructures and other things. But still, there is no pragmatic policy evolved by the government. But one thing, admirable thing was that in 2002, Arun Jaitley was a law minister, of course, it's a good vision. They introduced the concept of the fast track courts. But that concept was only, they should have widened or made it clarified that to other, the lower courts also. The district courts came, now the pendency is virtually, it is very surprising that not many cases are pending in district court levels, especially the criminal cases. They have been disposed of. But on the other hand, they have come up as an appeal and they have stagnated in the High Court. It is something like a sewerage blockade. This and population, I don't believe in this population ratio and the judge strength. It is a litigation and judge strength. It should be proportionate to the litigation, not the population. Many people say for 10 lakh, 20 lakh, one judge, and that's not correct. It's irrational. You must always, it should be proportionate to the litigation. Because in some places population may be small, high litigation rate. So it all depends upon the litigation, these things. And the non-cooperation, and whenever unfair advantage is there, quite natural. And on one occasion, the Arun Shouria, I think, Laws and Courts, some book he wrote, where he has a very scathing criticism against the lawyers, especially the criminal side. Most uncharitable statements he makes there. But I found that it is more out of ignorance than proper education. The criminal lawyer is branded as a greatest liar. In Indian context, if you look at, is a poor man, this Jethmalani, for arguing this Jessica Lal case, he stood virtually condemned. That was totally a very unpleasant, bad way of the media debate. Media is illiterate and media did not project the issue in a proper manner. It's a legal right to be defended. It's not that the moment you defend it does not mean that you are working for an acquittal. You are finding the truth. What exactly, even the CRPC says, even in a sessions trial, in a murder where life and death punishment is there, life and death punishment, when an accused confesses guilt, admits guilt to the charge, it is not necessary that the judge should convict him. Judge can still hold the trial. Because the circumstances under which the death takes place, whether it's a murder or any lesser offense, to investigate that. Therefore, it's based on a very sound ethical and rational values. In the Indian context, the sentencing policy is very hopeless. The moment the fellow is I admire the Macaulay for his Indian Penal Code, because it's an extraordinary work. With absolute precision, he has defined the offences. But one fallacy with Macaulay was that in sentencing, motive is not one of the relevant considerations there. A discretion is given to the judge, but motive is not reckoned as an essential criteria for imposing. Especially in death cases, the murder takes place. You have only three categories there. One is culpable homicide amounting to murder. It is punishable with life or death. Life in prison, death penalty. Earlier the rule was death and exception is the life. Now the rule is life and exception is death. Then you have culpable homicide not amounting to murder. That is dealt with on 304 Part 1 of IPC, where it says it is 10 years imprisonment or life imprisonment. Some discretion. And then in 304 Part 2, that is where a person commits murder without intention of causing murder or without intention of causing injury which is likely to cause murder, but with the knowledge that is likely to cause murder. Then it is a third category. There it is punished with 10 years. In all these defined these offence, you don't find motive at all. And as a judge, I really feel I am guilty. I have been convicting only a man with a soiled coat or a torn cloth. He suffers the life imprisonment. He suffers the punishment for 302. No, the persons who, for what reason? Just a land dispute or a boundary dispute, water sharing, or a fellow suspects the fidelity of his wife. For small silly reasons. Look at, he is a very good individual to the society. Except to that person offended, he is a very good social being. And for them also you say life imprisonment. A dacoit, a terrorist, a life imprisonment. What is it, death penalty? Why don't you be? Our sentencing policy is very, very irrational. And the moment you get convicted, you have no choice. That is why lawyers, when they have no maneuverability, they have to work only on avoiding conviction. When they have a scope for arguing on lesser sentence, they would not indulge in these unethical methods of avoiding conviction. They would also gracefully tell. Our Indian lawyer is bad because he is to operate with bad laws. Quite natural. When lawyer is asked to operate with a bad law, your Land Control Act, quite some unfair advantage is given. When a client comes, how can he advise something against the law? Unfair advantage is given by the law. You can't say, lawyer, if he becomes a saint, nobody will come to him. And it's unethical. So these are the things which normally the common man's perception, it's beyond the understanding of the common man's perceptions. Then you have this, the counter claim you have got. So supposing you file a suit, injunction suit is filed not to come and disturb. Defendant says, no, I am the owner and I am in possession, something like that. You must make the compulsory for the defendant to seek the counter claim if he is entitled to, not by way of separate suit. This is what happens in the courts every time we find in specific performance suits. The parties are misguided, and by the time they realize to file a suit to have the relief, then the time is lost. Instead, you say one comprehensive, in one go, you make a law. You make, of course, the counterclaim provision is there in Order 8 of CPC, but it is not made mandatory. Why do you make it optional? Most of the things, if you streamline I think it goes in a great way. Unfairness in legislation to be eliminated. The defendant's conduct and accountability in participation should also be insisted, or some strict procedures to be brought in. And then the persons who misuse law, you must make it declare it as an offence, and the provision itself. Then that deter the unholy elements from misusing the law. And then this court fee you abolish, 15% of the litigation comes down. And then precedent law, don't depend upon the precedent law, the courts alone to interpret what the law is. The moment you find some grey area in the legislation, immediately let legislature amend it, clarify it. It becomes easy for the courts to follow. And then the service of summons and other things. With all the development of technology, we are still on that pigeon carrying the letter, that pigeon methods, faxing and other things, we have not adopted. And then these penal councils are there. We ask them to take more than the court fee. This process fee is a very, very burdensome thing for a lawyer, because normally we find client may pay fee, but the process fee is virtually paid by the lawyer himself every time to avoid embarrassment in the court. He has to pay out of his pocket, and even 10 times, third chance, fourth chance also you are not served. What is this? Why should such a situation be there in a country? And that too is High Court summons also, third time, fourth time also it is not served on a civil side. What is that? What is wrong with that? So these are the things. About 40% of the cases, 30 to 40% of the cases that is pending in the High Court or anywhere I find, they are all at the miscellaneous level, the notice level. These are the things you have to bring about these things. And on criminal side, I said, the most favored person is the offender. He has right of silence. That means to say he need not say anything. Even in court also he need not say anything. Right of silence is absolute. And he need not explain. And level playing field is not there. So unless the sentencing on the hostile witness, the terrorizing, the witnesses become hostile and all that. And until that the trial doesn't commence. Unless you find some real solution, because the status quo is helping the unholy elements in the governance. Any rational changes is suicidal. And it's very unfortunate that the Supreme Court virtually declared that sanction, non-sanction is not very important when the merits of the case shows that he is guilty and all that. That should be ignored. Now the central government, the parliament brought about amendment to Prevention of Corruption Act to say that not only to the persons in service, even for retired servants you should have a sanction. What is it? Where are we? We are working at cross purpose. We are working for cross purpose. We are not really honest in our intentions. So basically, I tell you, the defect in the legislations, they are the main defects and unfair advantages in the legislations are the main contributory cause for the pendency. Judge is also helpless. When other side contest and all appeals are there, you pass some order, they will go in appeal and they get it stayed. Because here litigation pays. So it was said that crime never pays. That's wrong now. Crime alone pays now. Likewise, litigation alone pays. So these are the creases in our legislative system. Unless we do that. And after all, yes, a caution advice to given to all functionaries. Similarly, judges also require an advice, the proper training. Because they should update themselves. And in that direction, of course, we have created academies, judicial academies. Judges are trained. We are still in the beginning. It's because it's a new concept. It is not even a decade. Because any institution to grow 5 or 6 years is a very small period. It requires, in decades you have to measure. The success or the failures you have to measure. To take a social audit, it has to be in decades. And this is also a very essential thing, because judges have to be properly trained. They should know the law, apply the correct law. Because appeals arise because it was so said that an appellate court is created on a premise that the lower court may commit a mistake. Otherwise, where is that's the logic of it. Ultimately, that's the philosophy with which you have an appellate court. Why should you have an appellate court otherwise? And you want that some full point. Therefore, you say Supreme Court, because there is no appeal there. So it was so said that even the judgments of the Supreme Court also, sometimes they get reviewed. Judicial review is there. It is not as if, because we are men with free mind. We are open to criticism. We are open to, yes, if you point out, yes, there is something shortcoming in, we accept it and we revise our opinions. That is the hallmark. That is the virtue of the judiciary. That is the virtue of the judge. Where if it is pointed out, judge, you are wrong, this is wrong, then judge admits and he revises it. Maybe after the views, but it depends upon the social circumstances, social conditions. Judiciary is bad because we work in the quality of times where everything is deteriorated. When body has fever, high fever, every part of the body aches. You can't single out and say hand should not ache or a brain should not ache. We are also part of the system. We are aching. And with this brief presentation, I humbly conclude and I invite any of the questions.
Questions and answers. Those who want questions may kindly come here.
Friends,
Sir, if you are aware of all the problems
Please come
in the
here.
judiciary,
Please
what
come
is
here.
the dialogue process with the government and the makers of the law to implement these amendments? You know the problem. There are people who have to provide the solution. Is there a dialogue, or is the dialogue futile, or you have given up your efforts in getting the dialogue?
Sir, I am only a small speck in the system. I am a small speck in the system. Not that my voice is heard and acted upon. These are my loud thinkings. I shared my idea.
But is there a mechanism to?
As I said, this is to be created. Legislature has to activate itself. They should know the shortcomings and they should activate themselves. And more so, when collective decisions are taken, normally there is no decision. When collectively decision to be taken, then it will be always a pell-mell situation, no decision.
Then in a democratic setup,
That is the drawback of the democracy, we can't say. And we can't say it's a populist, there is no more rule of law democracy. I think you are one of the subjects. A great speaker, just Abhinay Tachalaya perhaps, would address you on the point. Yes, sir?
Sir, what is the difficulty in increasing number of judges?
No, that is being done.
Especially in High Court. At least the case to be decided within 1 year of the filing of this case in the High Court. What is the difficulty in increasing the number of judges to the level that the case is decided within?
The suggestion is not so easy to be solved, and then it has its own difficulties. Inexplicable reasons are also there.
Sir, may I ask a question? Of course, this is not related to today's subject, but nevertheless it is related to the judiciary. In the last 5-6 years, there has not been even a single woman judge in the Supreme Court bench. Can you throw some light why this discrimination?
No, I don't think that that's the correct way of looking at things. Just to have women does not mean gender justice. By appointing one woman, you don't say that an entire class of women get justice. There are different litigants are there. Sometimes the reasons are different. And now that Supreme Court has filled up. It's not, you can't look at saying that only you make somebody so and so, put him in the pinnacle. Entire class gets ameliorated or they benefited. That's not correct. The litigants, as a woman, there are sufferers, still there are languishing, that they are suffering.
Defendant's accountability
of profit, that notice has been issued. Whether he has an office of profit to tell that why extensions of time is given. If you ask me, do you have a job, I should say yes or no. No reason. That extension of time and also subsequently when he is adjudicated, what is the punishment given?
So the client does not directly interact with the court. The client has benefit of engaging a lawyer because he doesn't know the complications of the law and other things. Therefore, the moment you say he should engage a lawyer, that's a one step. After engage a lawyer, getting instructions is another step. And other excuses like fever, not well, or out of station, other steps. This is something like, it's a small hole becoming a pothole.
Exactly. Sir, continuing on that, what you said, small hole becoming a big hole, where virtually I'm facing a criminal case, it is absolutely irrelevant. But what's happening is that, is there any way that criminal cases can get completed fast, unlike a civil cases? More or less it's taking the same time. When it comes to hearing, trial.
There are really solutions. Our system of management of case, posting of case is very unscientific. We leave it to the discretion of the judge. We have not regulated by any norms. The judges normally in trial courts, they post about 50-60 cases. Hardly they can attend to 4 or 5 cases. Why should they post so many cases and ask so many people to come to court? This is, I tell you, in democracy sometimes stupidities have their sway. The scientific things are there.
My request is that.
No, I'll tell you this, even Supreme Court is really puzzled by the way in which these enact cases are there. 2 lakh cases are there. Hardly 5 to 6 judges have to manage.
No, either they have to increase the number of judges.
Yes, it is in the process, we see, and we recommend to the government. Government also will look into its financial position. They do it in trickling methods, not in downpours, they don't give the request. Buts and ifs always there. We are also human agency, prone to errors.
Sir Ramaswamy will propose vote of thanks.
I made it within time, sir. I overstepped the...
No, absolutely not. Our next program, ನಾಳೆ ಅಂದರೆ ಗುರುವಾರ ಸಂಜೆ ಖ್ಯಾತ ಇತಿಹಾಸಜ್ಞ ಪುರಾತತ್ವಶಾಸ್ತ್ರಜ್ಞ ಡಾಕ್ಟರ್ ಎಸ್ ನಾಗರಾಜು ಅವರಿಂದ ಉಪನ್ಯಾಸ ಇರುತ್ತೆ. ವಿಷಯ ಬೃಹತ್ ಭಾರತ. ನಾಳೆ ಸಂಜೆ ಜಸ್ಟಿಸ್ ಶ್ರೀಧರ್ ರಾವ್ ಹ್ಯಾಸ್ ಗಿವನ್ ಎ ವೆರಿ candid picture of the present state of affairs. Nobody can deny that delays and backlogs have been endemic. Justice Sridhar Rao has given a picture of the state of things and has also suggested many insightful remedial measures. However, we should also remember that there is another side to this. Of course, we know that there are heavy backlogs and so on and so forth. But at the same time, we should not forget. See, during the years 1999 to 2006, the quantum of annual disposal of cases in high courts increased from 9.8 lakhs cases to 14.5 lakh cases, an almost 50% increase in disposal rate, without commensurate increase in the number of judges. Now, the average judge of a trial court disposes of over 1,350 cases every year. This is far above international average. While speaking of mounting docket pressure and explosion in the number of cases, we should remember that government itself is one of the largest litigants in our country. Clogging of cases is but one aspect. An even more serious matter for concern is the quality of justice delivery. For heinous crimes, the conviction rate in our country is amazingly low, of the order of some 6.5%. This means an accused has a 93.5% chance of walking away scot-free. Comment is needless. In recent years, judicial activism has provided a much needed safety valve in our democracy by liberalizing access to justice. Judicial activism is not an aberration, it is an essential aspect of the dynamics of the constitutional court. Fast track courts, which Justice Sreedhar Rao mentioned, it is another positive development. As he indicated, in addition to increase in manpower, procedural reforms are crucial too for speedier and better delivery of justice. In this matter, the amendment to the Civil Procedure Code in late 1990s was an important landmark. It is an unfortunate fact of life that we are burdened with a lot of mindless legislation, as explained by the learned judge. There is now also an added advantage. Information technology support system, which is now available, which was not there earlier, this can fruitfully be increasingly harnessed by the courts. On behalf of Indian Liberal Group Bangalore chapter and the Gokhale Institute of Public Affairs, I express our warm thanks to Justice Sreedhar Rao for a most lucid analysis.